Hello everyone, so myself Gaurangi Kushwah and today I'm back with my new video on trespass to land. So in this video we'll be discussing about trespass to land. Trespass to land means interference with the possession of land without lawful justification. In trespass, the interference with the possession is direct and through some tangible object. Trespass is actionable per se, and the plaintiff need not to prove any damage for an action of trespass. To constitute the wrong of trespass, neither force nor unlawful mention nor actual damage is necessary. Trespass may be committed by entering upon the land of the plaintiff, or by remaining there, or by doing an act affecting the sole possession of the plaintiff in each cases without any justification. Trespass could be committed either by a person himself entering the land of another person or by doing same through some material object. For example, like throwing stones on another person's property, allowing cattle to stray on another person's land is also trespass. It is, however, no trespass when there is no interference with the possession. If the interference is not direct but consecutional, the wrong may be a nuisance. For example, to throw stones upon one's neighbor premises is wrong of trespass. To allow stone smoke from a ruinous chimney to fall upon those premises is the wrong of a nuisance. Planting a tree on another's land is a trespass, but if a person's plant a tree over his land and its roots or the branches escapes the land of to the neighbor, that this will be a nuisance. So going beyond the purpose for which a person has entered certain premises, Pereira versus Vandiar, or crossing the boundary where he has the authority to go, amounts to trespass. Thus, if a person who is allowed to sit in a drawing room enters the bedroom without any justification, the entry into the bedroom is a trespass. However, if the area to which a person is lawfully invited and one which is prohibited area has not been properly marked, a person does not become a trespasser merely by going beyond the area of invitation. So, where there is justification to enter the premises of another person, it's no trespass. In Madhav Vittal Kudva versus Madhav Das Vallabh Das, the defendant was the plaintiff's tenant. He was living on the first floor of the multi-storied building. He used to park his car in the compound of the plaintiff's building. The plaintiff contended that the parking of the car is in his compound without the permission was a trespass and sued for an injunction. It was held that the tenant of multi-storied building has a right to use the compound, if any, around the building or for the parking of his car or the vehicle without causing any inconvenience to anybody, and that right can be exercised without the permission of the landlord. A man is not liable for trespass committed involuntarily. For example, when he is thrown upon the land by someone else, but he is liable if the entry is intentional. Even an honest mistake may be no excuse, and a person may be liable for trespass when he enters upon the land of another person, honestly believing it to be his own. Trespass is a wrong against possession rather than ownership. Therefore, a person in actual possession can bring an action even though against the true owner. His action was wrongful. The trespasser is allowed to take the defense of justice. Title of third person, that is, the trespasser cannot plead as between some third party and the person's possession. The title of the third party is better. In Graham versus Speed, the plaintiff was holding the land under a lease which was void, but he was entitled to bring an action for trespass against the defendant who had entered the land without lawful justification, because any possession is a legal possession against the wrongdoer. Trespass is possible not only in the surface of the land but is also equally possible by an intrusion on the subsoil. For example, taking minerals from out of the subsoil, it's possible that the surface may be in possession of one person and the subsoil of another. In such a case, if the trespass is on the surface, the person is in possession of the surface alone and not the possessor of subsoil can sue that for that. Similarly, for trespass on the subsoil, the possessor of the possessor of the subsoil alone can sue. However, digging a hole vertically in the ground may amount to a trespass where the action can be brought by each one of them. Trespass ab initio. When a person enters certain premises under the authority of some law and after having entered there abuses the authority for committing some wrongful act there, he will be considered to be a trespasser ab initio to that property. The plaintiff can therefore claim damages not only for the wrongful act subsequently done by the defendant but even the respect of original entry, which is now considered to be a trespass. Misfeasance must be such that will render the presence of the defendant on the premises as wholly unjustified. In the case of Elias versus Passmore, illustrates the point. In that case, the defendant, certain police officers, entered the plaintiff's premises to make an unlawful arrest. There, they removed certain documents without having any lawful authority for that, which was therefore act of misfeasance. By the act of misfeasance, the presence there had not become wholly unjustified because the arrest, that is the lawful purpose, had yet to be accomplished. They were held trespasser only with regard to the documents which they had seized and not trespasser ab initio to those premises. Entry with a license. Entering certain premises with the authority of the person in possession amounts to a license, for the defendant cannot be made liable for trespass. For example, permitting a person to cut a tree on one's land. Section 52 Indian Easement Act 1882 defines license as under where one person grants to another or to definite number of other persons the right to do or continue to do in or upon the immovable property of the grantor, some which would absence of such rights be unlawful and such rights does not amount to an easement or an interest in the property. The right is called a license. After license is evoked, the license becomes a trespasser on land and must quit that place within a reasonable time. For that purpose of the right of license are revoked, license and licenses are considered to be of two kinds, a bare license and a license coupled with a grant. A bare license can be revoked, whereas a license which is coupled with the grants cannot be revoked. For example, a license to see a picture is a license coupled with a grant, and the cinema's authorities cannot revoke such a license. Similarly, a license to cut down a tree and carry it away is an example of license coupled with grant. In certain cases, the license, by terms of the contract, expressed or implied, may agree that even a bare license will also be revoked. Let's have a case law here. In Wood versus Leadbitter, the plaintiff, having purchased a ticket, went to see a horse race, and the defendant were the occupiers of the race course. While the races were still going on, the defendant asked the plaintiff to leave the premises, and on his refusal to comply with MAT, he was forcefully ejected by the defendant's servant. The plaintiff brought an action of assault. It was held that the revocation of license was effectual, and after the revocation of license, the plaintiff had become a trespasser, and ejection of the trespasser out of the premises was not an actionable wrong. So now trespass by relations. One who has the right to possess is by legal fiction deemed with he entered he have been in the position from the moment when he right to enter occurred. Thus, if an owner of property wrongfully outstated of possession manages to enter his premises, he will be deemed to have been in any position even during the period that is actually out of his possession, and he can bring actions for trespass for wrong to the property during that period. Actual physical contact is not necessary to constitute de facto possession, that is possession. In fact, for example, books and clothes at home and not see in a railway train. Trespass over airspace. In a person has an ownership of not only on the earth surface but also anything below subsoil and above airspace, the surface which is capable of being reduced into private ownership. In India, the aircraft act of 1934 makes it punishable offense for any person willfully to fly an aircraft to cause a danger to any person or property in land or water in the air but it contained no provision to absolute liability as in the English Acts. Defenses to trespass. The first defense here is defenses to trespass. Any justifiable entry or interference will negative liability for trespass. Justification by law, private defense, inevitable accidents, license, necessity, parental authority, etc. as well recognize lawful defenses for trespass. For example, a policeman can enter a private house through an open door late at night if he had reasonable grounds to believe that there is some disturbance which requires immediate investigation. Remedies. First is re-entry. If a person's possession has been disturbed by a trespasser, he has a right to use reasonable force to get a trespass vacated. A person who is thus entitled to immediate possession or use reasonable force and regains possession himself cannot be sued for trespass. Actions for ejectment. Section 6 Specific Relief Act 1963 gives a speedy remedy to a person who has been dispossessed of a immovable property otherwise than in due course of law. Action for Mesne Profits Section 2 subsection 12 CPC. Apart from the right of recovery of land by getting the trespasser ejected, a person who was wrongfully dispossessed of his land may also claim compensation for the loss which he had suffered during the period of dispossession. Mesne profits refers to the profits taken by the defendant during the period of his occupancy. Distress, damage, feasance, seizure, detention. The right of distress, damage, feasance authorizes a person in possession of land to seize the trespassing cattle or the chattels, and he can detain them until compensation has been paid to them for the damage done. The idea is to force owner of the chattel to pay compensation, and after the compensation has been paid, the chattel is to be returned. So by this, I end my video here. Thank you so much. I hope you have understood well, and thank you so much. Stay safe, stay healthy.